I have been practicing attorney discipline defense since September 2001. Prior to September 2001, I worked for the State Bar of California as a staff attorney, as a discipline prosecutor, and as a manager for approximately 12 years, March of 1989 through March of 2001. In the mid-1980s, the State Bar discipline apparatus had been chronically underfunded for many years. There had been an explosive growth in the numbers of lawyers and the numbers of complaints against lawyers. And this series of newspaper articles prompted a massive overhaul of the State Bar discipline system, spearheaded by the state legislature, and specifically Senator Robert Presley of San Bernardino, who took the lead in sponsoring a number of legislative changes that essentially brought the State Bar discipline system, which had operated, I want to say almost like a mom and pop operation for many, many years, into the modern era and created the modern State Bar discipline apparatus that we know today. There were many reforms. Among the reforms was the creation of a full-time State Bar court, the first such court in the nation. Prior to 1989, the State Bar had relied on a system of volunteer referees, several hundred volunteer referees, lawyers who weren't full-time employees of the State Bar, but who served as hearing referees in the discipline cases on a per diem basis. That system of referees was slow, inconsistent in result, and was part of the criticism of the State Bar that appeared in the mid-1980s. Discipline hearings sometimes took years to complete because these were attorneys in private practice. All the calendars had to be coordinated. And they were people that had received relatively little training in the discipline jurisprudence. So the results were sometimes inconsistent. The new State Bar Court was empowered to publish decisions. The review department, the appellate court within the State Bar Court, had the power to publish, to issue published decisions that would count as precedent in State Bar Court. So this was a very dramatic reform, moving from this all volunteer system to a system of professional full-time judges, both in the hearing department and on review. Of course, the prosecutor's office was going through its own changes. One of the reforms of the 1980s was a almost doubling of State Bar dues. The amount of money that lawyers had to pay to the State Bar to continue to practice more or less doubled. That money was used to fund not only the new State Bar court apparatus, but also to expand the Office of Chief Trial Counsel, the State Bar's discipline prosecutor, to expand that office, to hire new attorneys, new investigators, and essentially work on cutting down the investigative backlog and to make the system work faster. One of the stories that had appeared in the San Francisco newspaper had to do with the State Bar's investigative backlog, which by the mid-'80s had reached something like 4,000 cases. One of the jokes at the State Bar was about a room that was called the TNT room. And the joke was, it was called the TNT room because it was so full of files it was about to explode. Well, if you're talking about the relationship between the new full-time professional court and the prosecutor's office, that relationship was not at all smooth at the beginning. The prosecutor's office came in for a lot of criticism from the State Bar Court in the published decisions in the first 5 or 6 years of the State Bar Court. There was a level of criticism of the practices of the office that was found very unpalatable to the discipline prosecutor's office. They had, of course, been used to a system of volunteer referees that were, I think, relatively maybe control is the wrong word, but they weren't used to coming in for this kind of criticism. The state bar prosecutors felt that the review department was being too lenient with respect to the levels of discipline that it was recommending. So there was a perception that the court was too lenient, a perception that the court was too critical of the prosecutor's office. So there was actually quite a bit of unhappiness with the state bar court during the first 6 years of the appointments. So from the point of view of the prosecutors, they weren't terribly happy with the way the full-time professional court was working. And that led to some dramatic changes after the first era. The first round of appointments, when those came up for renewal, their 6-year terms, when those came up for renewal, there was a wholesale change in the court. Judge Perlman was replaced with a new presiding judge. A number of the hearing department judges were also replaced. It's important to remember that the state bar discipline system is this tiny, relatively tiny institution within the state bar even. There are 5 hearing judges, 3 review judges. There are approximately 35 to 50 deputy trial counsel who try the cases. And there is a relatively small core of discipline defense counsel who do this full time. Full-time practitioners of discipline defense, there are a lot of people that dabble in it, do a little bit of it in conjunction with other practice areas. But really the full-time defense bar is maybe 15 lawyers, at most. The people that advertise in the California Lawyer and other publications. It's a small world, and everybody very soon understands the foibles of everybody, of all the players in this small little world, in terms of, is this judge going to be more receptive to this kind of argument? Is this prosecutor going to be more hard-lined than another prosecutor? So one of the problems with the full-time professionalization of discipline, in my view, is that it has created, to some degree, a bubble. You've got full-time professional prosecutors, full-time judges, and full-time defense counsel. And everybody has gotten very specialized in what we do. Now, that's supposed to lead to better results. The theory is that's going to lead to better results. But there is sometimes a sense of disconnection in that little world between what goes on in the small, dare I say, incestuous world of the state bar and the wider profession and the wider world. So, and that is a problem when thinking about the discipline system. When you evaluate the things that players in the discipline system do, you have to understand that from their perspective, they are part of a bureaucratic institution. And like every bureaucratic institution, that institution has its own, sometimes not so obvious, needs and drives that push the institution in one direction or another. So many people, many clients, many lawyers, when they first become involved with the discipline system, want to try to think about it in terms of what they know. The civil court system or the criminal court system. They want to apply those models and modes of reasoning to what happens in the state bar court and the state bar discipline system, and they're not always applicable. It's that there's a whole history, there's a whole range of issues that have been present for a long time and are present all the time in discipline work that aren't obvious to the person that's coming in from the outside. One of the changes the state legislature enacted in the late 1980s were rules requiring investigations to be completed within a certain time period. And at the end of every year, the state bar is required to report to the legislature the numbers of cases that haven't met that threshold, that haven't met that deadline. That's known as the backlog. Governments being what they are, the backlog number assumes this incredible importance in terms of the state bar's relationship with the legislature. Numbers are something that are easy to understand, easy to quantify. We can look at a number and we think instantly grasp some relevant information about how the discipline system is working. So what's tended to happen for years in the discipline system is toward the end of the year, because these statistics are required to be reported by calendar year, toward the end of every year, there tends to be a speed up in the work of the discipline system, because the Office of Chief Trial Counsel wants to report good numbers for that year. So what generally tends to happen is toward September, October, people look at the numbers and say, well, they're not looking real good now. We better, throw some more coal on the boiler, get some cases going. And generally what happens is after the first of the year, everyone's tired and they tend to slack off. So the discipline system for years has gone through this cycle. And part of what happens in this cycle is that there's a rush to dispose of cases toward the end of the year, because we have this artificial deadline. Cases got to be settled or filed before the end of the year. So toward the end of the year, this is what I'm going through right now. I'm in the middle of the end of the year rush. I'm essentially trying to resolve a half dozen discipline cases, settle them, if possible, for the best possible dispositions. And I have to kind of do this all at once now, because we have this artificial deadline looming. So sometimes you see investigations that aren't fully fleshed out. You see cases that they give you notice of intent to file on that are barely investigated, but they're more than 6 months old and they're going to fall into the backlog. So now we have a case that's relatively unformed, not worked up on the prosecution side. And we're rushing at the end of the year to try to develop the information necessary to resolve this case, close it, maybe settle it for what it's worth. That's one example of an artificial state bar land phenomenon that distorts the process. A profound level of fear. A profound level of fear. The bar has to get authorization on a regular basis to collect its dues, to tax the attorneys of California their dues money to fund its operations. It's a big operation. Discipline alone is an $80 million a year operation between the state bar court, the prosecutor, client security fund, and other functions. It's a huge operation. So if the bar can't collect those funds, it can't operate. And the legislature and the governor have to agree on a dues bill. I was fortunate enough, in retrospect, to go through the state bar shutdown of 1998 and to refresh your recollection. In that year, Governor Pete Wilson vetoed the state bar dues bill. The bar was left basically the effect of that was to cut the bar's funding by 90%. Because the state bar had such a rocky relationship with the state legislature, a relationship marked by mistrust, profound mistrust of the state bar by Democrats and Republicans alike. In 1998, it was impossible to get them to agree on a dues bill. In June of 1998, we were laid off. 90% of the state bar personnel were told to go home. And the bar was shut down for 6 months until finally the Supreme Court rode to the rescue, imposed a special assessment. In other words, the Supreme Court said, we have the power to levy a special assessment on members to pay for the discipline function, which is an essential function. Even if the legislature won't act, and the legislature had not acted for well over a year at that point, we can impose a requirement on our own. Every organism learns from near-death experience, and that was a near-death experience for the state bar. So the bar knows that the legislature, it was created by the legislature, it can be uncreated by the legislature. Recent years, we've had the legislature essentially impose a dramatic change in the governance of the bar, the so-called governance controversy. In 2010, the state legislature told the bar, as part of the dues bill, that we think you need to study your governance structure. And here's where we start to get into the deeper politics of the state bar. You need to study your governance structure because we think that you are insufficiently zealous when it comes to public protection. That's essentially what the state bar told, what the state legislature told the state bar in the dues bill. The evidence that the state bar had been insufficiently zealous was laughably weak in my view. And this direction from the state legislature really was an expression, again, of this deep and lingering mistrust of the state bar as an institution, a deep and lingering mistrust that goes back 30, maybe 40 years. Changes were made in the statutes that govern the state bar's operation to make it clear that the number one mission of the state bar is public protection. In other words, they sort of elevated that duty, which I don't think anyone had really ever questioned that was one of the most important functions of the state bar. But the legislature gave them clear direction that this is your paramount function, and anything you do that detracts from this mission is viewed unfavorably. At the same time, the number of members of the Board of Trustees elected by attorneys was dramatically reduced. One of the perceptions in the governance, one of the perceptions underlying the governance struggle was the idea that attorneys had too much control over the state bar. You know, the myth of attorney self-regulation, as I call it. The governance controversy, I hope that's finally driven a stake through the heart of that vampire, because the idea that lawyers regulate themselves has been a myth for a long time. It's a myth that people like former State Bar President Kelly still tend to evoke. But in fact, the state legislature has been firmly in control of lawyer discipline for a long time, and this governance controversy only should solidify that perception. The public protection zealots have essentially won in their long effort to control the direction of the state bar. The Board of Governors and now the Board of Trustees, these are full-time, mostly practicing attorneys, now some full-time lay people, who do this on a volunteer basis. They rely on staff to process information, present them with information. They're part-timers. Staff, of course, are full-time. And oftentimes within the state bar staff, I can tell you I've heard many negative sentiments expressed about the Board of Trustees, formerly the Board of Governors, and various state bar presidents. Sentiments like, well, wait till you hear what this crazy state bar president wants to do now. I mean, The State Bar President, of course, is a member of the Board of Trustees. He or she is elected for 1 year. Their last, they serve for 3 years, then they're president for 1 year. And every president wants to leave some kind of mark or legacy on the institution. Staff knows that board members come and go, but staff will be there forever, like many government institutions. They are essentially political appointees, and they will be gone someday. And staff will continue to run the State Bar in the way it's been run, like every government agency. There's that level of tension. The extent to which RAD actually exercises oversight over what the discipline system does changes with the times, changes with the personnel, changes with whether the members of RAD are truly interested or not. Every year, the State Bar holds what they call Discipline Day, which is a day-long orientation for Board of Trustees members to come and learn how the discipline system works. The reports we receive are that most of the Board of Trustees members find it to be a tedious day. They're not terribly interested in the nuts and bolts of how the discipline system works. And so with respect to 80% of what the State Bar does, the level of engagement of the average member of the Board of Trustees, or RAD, is problematical. I mean, I know there are RAD members who take what they do very seriously, but if you ever go to a Board of Trustees meeting or a committee meeting, I mean, you will see that these part-timers are overwhelmed with massive amounts of information. And frankly, they're not going to be around for ever. So staff really has a lot of power to determine which direction the board goes. When the bar system was overhauled in the 1980s, they created a new position of chief trial counsel. It actually wasn't a new position. There was a chief trial counsel before that. But they created a position of chief trial counsel that was subject to approval by the state legislature. In other words, the top discipline cop has to be someone the legislature approves of. And they specifically made the top discipline cop, by statute, not subject to the supervision of the chief executive officer. The idea being that, well, we're kind of afraid this this confusion of functions between trade association and government agency. It would be a conflict, if you will, for the chief executive officer to oversee both. So we're going to create just one senior executive who will be responsible for discipline prosecution. And that person will report to the RAD committee. That was the line of authority. So historically, the chief executive officer had very little to do with discipline until the Jim Dunn era. Let me explain it this way. I mean, Jim Dunn was brought in because the State Bar understood that it was in serious trouble on a number of issues. Judy Johnson, the prior executive director, someone who had been chief trial counsel, actually, someone I'd worked for very closely. I worked very closely with Judy. Had been executive director for 10 years. And there have been a lot of problems on her watch recently, including a rather well-publicized embezzlement scandal at the State Bar in San Francisco. At the same time, there was this pressure from the legislature on the governance issue. So the Board of Governors, now Board of Trustees, turned to someone who had in my view, apparently the political connections to help the State Bar in its hour of need. Mr. Dunn had been a state legislator, a successful attorney in private practice. He had been at one point the executive director of the California Medical Association, a very powerful trade group, one of the most powerful trade groups. I don't know if that's still true, but I'm sure the CMA still gives a lot of money away in Sacramento. So, Mr. Dunn's whole hiring was obviously to get somebody in there who has the political savvy to restore our reputation with the legislature. And to that extent, of course, we don't fully know what goes on behind the scenes. Part of the interesting challenge of the State Bar is reading the tea leaves, trying to figure that out. But it's pretty clear that Mr. Dunn has exercised more power than any executive director, at least since I've been involved with the bar. And I'm pretty certain that the appointment of Ms. Kim as Chief Trial Counsel was in part his doing. I'm certain that the resignation of Mr. Towery was prompted by Mr. Dunn, based on what I know of Jim Towery and the way that all unfolded. And the stricture in the legislation that seems to say the executive director has no authority over the discipline system seems to be largely ignored in the last 2 years. Mr. Dunn, of course, made the famous prediction about resolving the backlog issue. So I think he has exercised a degree of influence that wasn't contemplated when the State Bar was reformed in the 80s. The whole point of making the executive director not in charge of the discipline system was to remove politics from discipline. And that's essentially been undone. The discipline system now is it never actually removed the discipline system from politics. Let's be realistic. But that was ostensibly what it was supposed to do. The discipline system now is completely steeped in politics. Well, it's not functioning as a trade guild. Except in the most sort of peripheral ways. That, in terms of advocating the interests of the profession, that began to be gutted with the Keller versus State Bar of California decision. Well, remember, one of the criticisms of the bar, and folks may have forgotten this, one of the criticisms of the bar that led to Pete Wilson's veto of the dues bill was the idea that the bar was engaged in various kinds of political activities using members' dues. Governor Wilson, I think, was highly offended when the Conference of Delegates of the State Bar, if I recall correctly, condemned his stand on capital punishment. And that was one of the activities that Pete Wilson said the bar is too political. That was one of the first significant cracks in the facade of an integrated bar that functions as a trade association as well as a government agency. It truly is in a conflict, but the trade association aspects have withered away to the point where it's a trade association in name only. I still get clients come to me, attorney clients come to me and say, I'm shocked that the State Bar is being so harsh. After all, isn't it our bar association? I thought they would understand what I'm going through. I am kind of astounded that I still hear that, but there are still significant numbers of lawyers who cling to this idea that the State Bar is there to help them. And unfortunately, that misperception sometimes creates difficulties they have in understanding what's going on in the discipline process. They don't understand that over the last 30 years, we have moved from examiners became deputy trial counsel, like deputy DAs. The process has moved from discipline regulation. It's moved steadily in the direction of a criminal prosecution model. Well, if you are disciplined, if you're subject to public discipline in California, which means if it's a public reproval or a greater level of discipline, you are required to pay the State Bar's costs. those costs, which are intended to cover both the out-of-pocket expenses, the overhead expenses, as well as attorney's fees, are calculated on a rising scale. I call it a ladder. And the longer the discipline proceeding goes on, the more you pay in costs. For instance, if you settle a discipline case before they actually file formal charges, your base cost is going to be a couple $1,000s. But once they file a notice of discipline charges, the amount of costs rise dramatically. If you settle a case within the first 120 days of the proceeding, you pay a certain level of cost. But magically on day 120, those costs go up because now you're preparing for trial. If you have a one-day trial, if you settle the case after the filing of a pretrial statement, or have a one-day trial and a decision, you pay about $7,000 roughly. But if you go to a two-day trial, that doubles to almost to $15,000 or more. In other words, as you go through the discipline system, you pay more. If you appeal a decision to the review department, or even if the other side appeals it to the review department, if the prosecutors appeal it, your costs go up even more. So part of the reason for this ladder type structure is because the Office of Chief Trial Counsel didn't want to really keep timekeeping records in terms of how much attorney time it was taking to process these cases. So this is meant to be sort of a statistical average of what we think the average discipline case is going to cost. Not what it really costs, but sort of a guesstimate of what the average costs. We're going to sock you with the average cost. Part of the problem with the cost structure is that the bar will recover these costs if they prevail on any charge. The respondent in a discipline proceeding is only entitled to their out-of-pocket costs, not their attorney's fees, and only if they're completely exonerated. In other words, the bar might charge you with 20 different things, and if they find you culpable of one, you pay full freight. You might go to a trial. You might go to a multi-day trial to sort through those 20 charges. 19 of those might get thrown out. I mean, it's conceivable that you might have one discipline charge and you might pay tens of thousands of dollars in costs to sort through the other 20. In other words, there's no penalty for overcharging. In fact, there may be an advantage to the prosecutor in overcharging, because by overcharging, you increase the leverage on the respondent to plead to something. The idea is, well, we've got 20 charges we're going to file against you. We're going to accuse you of moral turpitude. We're going to disbar you. If you don't take our settlement offer, we're going to file charges. We're going to try this case. We're going to disbar you, or you're going to have a multi-year suspension. You're going to be responsible for all these costs. Creates a lot of leverage, no incentive not to overcharge, and frankly, they do overcharge. They do overcharge as a tactic to gain the advantage in settlement negotiations. You may have valid defenses. You may have, your case may be, let's face it, most people that go through the discipline system are culpable of some kind of misconduct. But not everybody is, and not everybody to the degree they're charged. You may have valid defenses to a number of those charges, but the cost structure penalizes you. In other words, if you want your day in court, if you want to hold the state bar discipline apparatus to its burden of clear and convincing evidence, you're going to have to pay for that opportunity. And then even if you're found culpable of some minor thing, you pay these enormous costs for the opportunity to vindicate yourself. That's one way the state bar discipline cost structure is unfair. There should be some mechanism to prevent the state bar from being able to do that. And some kind of cost shifting, or one of the things that we're talking about, Discipline Defense Counsel, is something like a 998 procedure, where if you make a good faith offer to settle the case for a certain level of discipline, and the bar doesn't take that offer, and you do better at trial, then the bar loses its ability to charge some of those onerous costs. Some kind of cost shifting mechanism that removes the incentive to overcharge and frankly would build an incentive into the system for state bar prosecutors to consider carefully what they can prove and what they can't prove before they get into state bar court and waste everybody's time and money trying charges that are just not supported by evidence. We opposed it when it was suggested. It was suggested as part of the state bar's alleged push for transparency. And I probably shouldn't say alleged push. The bar, when it comes to the misdeeds of lawyers, transparency, the bar's all in favor of transparency. When it comes to certain of their own activities, transparency is less of a priority. But the idea was that the public had a right to know what a lawyer was charged with. And the basis of that argument was that, well, the process is confidential until charges are filed. When charges are filed, it is a public record. Before they posted these on the internet, anybody could have gone down to state bar court, looked at all the recent filings, seen who was being prosecuted, seen what they were being prosecuted for. And the idea is, well, now since we're in the information age and more information is always better, which I think is maybe one of the chief fallacies of our time. More information is always better. We'll put these on the internet so that some consumer who's searching for a lawyer will be on notice that this particular lawyer is subject to charges. I understand that argument. It's a very powerful argument. It's hard to argue against it. But the argument against it has to do with the nature of the discipline process and the kind of uses that information might be put to. Anybody who's worked in the discipline system for any length of time knows that what's in the notice of discipline charges is not necessarily true or even provable. And there have been enough cases where the state bar's failed to prove its charges that we can say that merely because it's in the notice doesn't mean it's true. Of course, but of course, the whole premise of posting it, though, is the assumption that it is true. So although you have this interesting disclaimer that says these are merely allegations, the attorney should be presumed innocent until proven guilty, in the real world, every consumer who reads that is going to assume it's true. Otherwise, why would it even be there? So we have this interesting fig leaf disclaimer that says, well, we're going to tell you all the bad things this lawyer did, but they're only allegations. Make your own decision. So there's this kind of inherent duplicity here that we're going to somehow cure this problem by a disclaimer. The second problem is that now this information, the information age, the digital media, makes, the motto of our time is you can't have too much information. You can't have too much availability of information. It matters less if the information is accurate or good. It matters more that it's available. I mean, that seems to be the sort of the zeitgeist of our times. So I have clients who have been in court and have had opposing counsel march into court waving the notice of discipline charges like a bloody shirt, of course, in an effort to slime opposing counsel. So there's an impact obviously an impact on clients when opposing parties can basically attack their lawyer using something like the notice of discipline charges. So it harms the attorney, it can harm the attorney's clients. So we opposed it. We lost on that issue. But the state bar president at the time, I remember the board of trustees meeting where we talked about it, Ambassador Blyke, who's just returned from Australia, stated what I think is the most important point. He said, well, we're going to approve this proposal, but the disciplined prosecutors need to understand what a powerful weapon they have. They have, the publicity of the notice of discipline charges, premised on transparency, essentially gives an economic weapon to the state bar where they can destroy a lawyer's practice without ever having to prove their case in court. And that's kind of the ultimate problem with the accessibility of this information. It may not be true, and the mere fact that it exists means that by the time we get to state bar court, there essentially might not be much of a practice left for the lawyer to even defend. Again, what I'm talking about is not something that you'll find on any official policy description or anything committed to writing. It's really based on some of the reports I've received from people who've interacted with Supreme Court justices and their own perception that by and large the justices aren't terribly sympathetic to anybody in the discipline system. And I think, obviously, people in the state legislature, the public protection zealots, as I call them, think the state bar has been too lenient, too slow. I sense that there is a feeling that we simply have too many marginal lawyers, and the job of the discipline system, really, although we say it is to protect the public, in essence what we're doing is creating a system that will remove people from the profession based on levels of discipline that are far harsher than necessary to really protect the public. And it's really more of a description of what I think the psychology of the discipline system, where it's at these days, in terms of, we went hog wild admitting people to the legal profession in the 70s, 80s, and 90s. And I formed a sense very early on working at the state bar that the people at the state bar felt that we had in fact just admitted too many marginal practitioners. And that was 20 years ago, before we had the current economic meltdown in the legal profession. One of the things we've never been able to address in California is the proliferation of third and fourth tier law schools. Law schools that churn out people with JD degrees, and law schools that some of them have bar passage rates always below 50%. We've always had a great toleration for wide open legal education, unlike other states where you have to go to an ABA accredited school to even sit for the bar. And many of the lawyers who go to these law schools are just simply not really prepared to practice law. Not everybody, but a significant number of them either won't pass the bar exam, or if they do pass, they just simply won't be able to be effective practitioners. They don't have the skill. So, I mean, there's definitely going to be a shakeout in the profession. I anticipate that at some point the profession in California will probably cease growing and may even contract. I think that's likely to happen over the next 10 or 15 years. We're already seeing a dramatic contraction in the number of people going to law school. That's down something like 20%. So I don't think this is a conscious thought on the part of people in the discipline system, but I think it operates in the background. Attorneys think the State Bar is representing their interest in Sacramento. It's not. It's a government agency. It can't do that. There is no entity that can do that. And there needs to be some kind of statewide entity. The California Conference of Bar Associations is a fine institution, but I don't think it can do the kind of lobbying and representation that I think the lawyers of California need. I think it would be preferable, my own preference, and this is a conclusion I came to very early in working for the State Bar within a few years, that it would be better to separate out the trade association or guild functions, better done by a private entity, and let discipline be done by an independent agency within the judicial branch, the way that judicial discipline is done. Let's call it the Attorney Discipline Authority of California. Make it an independent agency within the judicial branch, like the Commission on Judicial Performance. Remember, that took an initiative to get that change. This might take an initiative as well. I hope that people do find this of interest. My experience is often when I start talking about this stuff, eyes tend to glaze over. And I think that's, again, part of the bubble mentality that the State Bar has put itself into. Most lawyers, I mean, they may read the California Bar Journal, they may skim the discipline decisions, but most lawyers are not interested in the process. It's kind of like, well, let's go down to the slaughterhouse and see how they make Oscar Mayer wieners. Nobody wants to do that. And so, you know, when we have issues, I'm always astonished by the lack of public comment on the part of lawyers. And to some degree, that is probably the State Bar not really publicizing it. But it's also the fact that most lawyers have their nose to the grindstone. They're so busy trying to survive in this contracted economy. They don't really want to pay attention to issues of discipline. Discipline is something that only happens to other guys or girls. If I've heard it once, I've heard it 1,000 times. I never expected to be here. You know, I've worked hard, I've tried to do the best for my clients, and now after 15, 20 years, I'm involved in a discipline proceeding. How did this happen? I've spent 20 years trying to get people interested in this topic, and it's gratifying to have your interest, but I often get a profound lack of interest even by lawyers in this. I'm going to sound like a grumpy old man now, and I guess I am. There was a point in our profession where lawyers were considered public citizens to the extent that they were deeply involved in the fabric of civic life, politics, all kinds of issues. That's changed to the extent that we're now so specialized and we're so focused on our own economic activity and survival. It's gotten very competitive that we, you know, I have a sense that we're not as involved in the wider aspects of the profession and maybe some of the wider aspects of the world as well. Of course, there are exceptions to that. But most of the lawyers I meet are basically just have their nose to the grindstone. Obviously, I meet a select sample. They have their nose to the grindstone, working to survive. And they maybe have an interest in legal ethics, though many lawyers shy away from that as well. It's frightening to them. Frightening. It's like, we don't want to know about legal ethics. We might find out we're doing something wrong. But many lawyers just don't have an interest in the discipline system itself. They might have an interest in legal ethics, but they don't want to see how the sausage is